Thanks, Dana. And I'm going to talk to you about the current laws in respect to electronic data. Messages sent to and from a company computer can be monitored by your employer. This includes personal email accounts and instant messages. Computers are your employer's window into your workspace. Software can be used to see screenshots that are stored in the computer's hard drive, and employers can monitor web surfing as well as keystroke monitoring that is typed and how many keystrokes per hour. Computer monitoring can track the amount of time an employee is away from the computer or idle time at the computer, as well as used to evaluate the employee's work. Employees do have some protection from monitoring under certain circumstances. Union contracts may limit the employer's right to monitor. Also, public sector employees may have some minimal rights under the United States Constitution. In particular, the Fourth Amendment, which safeguards against unreasonable search and seizure. Some employers do notify employees in memos, handbooks, union contracts, meetings, or stickers attached to the computer that they are being monitored. Computer monitoring can also be accomplished without the employee's knowledge. In most states, employers can listen and record phone calls. California requires they be informed by a beep tone or a recorded message. However, federal law regulates phone calls going outside of California can have unannounced monitoring. Telephone numbers dialed can be recorded and the length of each call. Many workplace privacy court cases have been decided in the employer's favor. Employers may also use cameras to monitor employees' productivity and prevent internal theft. Currently, federal law does not prevent video monitoring even when the employee is not aware they are being monitored. Courts have, however, upheld employee privacy in a locker room or in bathrooms. There are some state laws, such as in Connecticut and labor unions, that surveillance is forbidden. Video cameras that also capture audio recordings may be subject to some laws relating to audio recordings, including wiretapping and eavesdropping. Federal law does not prohibit audio recording of phone conversations as long as one of the parties on the call consents to the recording. There are 12 states that have laws that require that all parties in the conversation consent to audio recording. The rest do not. New technology makes it possible for employers to monitor employees' telephone, internet usage, voicemail, and it's virtually unregulated. Your employer may listen, watch, and read most of your workplace communications. Technology provides insight into employee behavior based on digital footprints utilized to evaluate employee performance and conduct. Recent surveys have found that the majority of employers monitor their employees in some form. They are motivated to know if employees are doing a good job and by concern over the increasing role that electronic evidence plays in lawsuits and government agency investigations. When an employer has a policy regarding an issue in the workplace, including privacy issues, that policy is legally binding. This can be done through employee handbooks, via memos, and in union contracts. Laws concerning online privacy are still being developed, but currently there are very few laws regulating employee monitoring. The U.S. Supreme Court largely has taken a hands-off approach to regulating the Internet and online privacy in favor of free speech. Lisa's next, and she's going to tell you why organizations implement email and Internet policies. Thank you.